Public Affairs very much thanks Residco, our sole corporate underwriter, for helping to make the production of this show possible.
You need to be able to have judges who are going to go through that process and make that determination. Is this person too dangerous to someone or to the community to be released? Is this person likely to be a willful flight risk? And then the important part that people don't understand is when that determination is made, that criminal defendant has a right to ask the appellate court, nevertheless, to let that person out of jail. We are a nation of laws to apply fair decisions that get decided the same way for everyone. Basic fairness. That's what we're looking for from our courts.
So that's the court. Welcome to Public Affairs. Look, a great show today. We are speaking with Judge Kenton Skarin, and he is running, he's a trial judge in DuPage County and Circuit Court of DuPage County, and he is running for the appellate court in the state of Illinois in the 3rd District. There are about 56 or so appellate judges in the state of Illinois. There are 7 in the 3rd District when he's running. But, you know, the important thing is a major matter that concerns almost everybody in the state of Illinois to a varying degree is crime. And we'll start out talking about crime because crime is a major issue for trial judges where Judge Skarin practices in DuPage. And it's a major issue if he's elected to the 3rd District of the appellate court in the state of Illinois. And why is that so, Judge Skarin?
Well, Jeff, it's because right now, after the Safety Act went into effect on September 18th of last year, since that time, the appellate courts have gotten buried by appeals. What people don't understand is that you can appeal a detention determination and ask the appellate court to let you out of jail. There have been 2,000 of those requests just in the first 5 months that the law was in effect.
And that, putting that perspective, in the decade before,
yes,
before that Safety Act was passed last fall, or became effective last fall, how many appeals were there on detention issues?
There were 171 in 10 years. So 17 or so times a year on average, somebody would ask for a bond determination to be modified.
Right.
Now in the last 5 months, after the Safety Act went into effect, we've had 2,000.
Dealing the bond decision, pretty similar, we'll get into that in more detail, to the detention decision, but it was 1 or 2 appeals a month previously with that general subject. Now it's about 400 a month. Right?
That's the approximate
that's
number.
Huge. That's
yes.
huge.
And the Illinois Supreme Court has gone on record as saying that this is essentially crushing the appellate court's ability to do its job. They're just not set up to handle that kind of volume. So this is a major issue that is immediately impacting not just the criminal area, but also the appellate court's ability to do all of the other important work it does.
So we'll come back to that. I want to give you a little bit more background, or let Judge Skarin tell us a little bit more about your relevant background, because you grew up in Wheaton, right?
I did.
In fact, you spent almost your entire life in
I've lived in Wheaton my entire life, except for a couple of times I went across country to work for a couple of federal appellate judges.
So, and you went to North Central College in Naperville, right?
I did.
Graduated, bachelor's in history.
Bachelor's in
honors.
history, summa cum laude from North Central in Naperville. Yes, sir.
Took a little time off from school to be a trader, not spelled Trader, a bond trader?
I did. Right? I worked in fixed income securities for about 2.5 years or so, and then I had the chance to go back to Northwestern Law School on a full academic scholarship.
So you've always done well academically, and that's important. Why? Why is that important? I mean, you did pretty well at Northwestern Law School, would you say?
I did. I graduated first in my class from Northwestern University School of Law.
So that's first in a class of 200.
About 240, 245 my year, but yes.
Important leapfrogging ahead, because that gives you a shot at having an important clerkship, working essentially side by side with either an important federal appellate judge, which you did.
I did.
Yeah, with
yes.
Judge J. Harvey Wilkinson, right?
That's correct. So if you do really well at a really good law school, you're at least eligible to apply to work for a federal court of appeals judge. I was lucky enough to do that for J. Harvey Wilkinson on the Federal Fourth Circuit Court of Appeals, which covers all of Virginia, West Virginia, Maryland, North and South Carolina.
So people know, if you're a law student, you know, well, it's clerking for the Fourth Federal Court District, Appellate District, Fourth Circuit.
Fourth Circuit Court of Appeals.
But clerking means you're working side by side. You're working with Judge Wilkinson and cranking out opinions and helping him think through these things. You're getting some interaction with the other judges on that Fourth Circuit Court of Appeals.
That's correct.
It's a big deal because you are running to be, what are you running for here?
Running for the appellate court in the 3rd District, which is all of DuPage County, all of Will County, all of Iroquois, Kankakee, Grundy, Bureau, and LaSalle County. So 2 million people basically west of Chicago and south of Chicago.
So this is like a job interview. We're helping you because you, the voters, the people watching this, and we hope we can get this around so a lot of people can see this in the 3rd District, because all of you, it's 2 million people who population is about 2 million in the 3rd District. They're probably going to be, come November 5, about 1 million registered voters voting on you as a Republican. You run as a Republican, your opponent is a Democrat, right?
That's correct.
You're not political as a judge, but the Constitution sets this up in Illinois that elections will be voting for our judges in the circuit courts and in the appellate court and in the Supreme Court. Is that right?
Yeah, it's actually one of the questions I get a lot, Jeff, is why on earth do we elect judges on a partisan ballot? And it's a fair question. When voters ask that question, they're right. It makes no sense to have partisan judges, but that's the system we have, and so that's the system we're working with. But it's an important point because judges are supposed to follow the law regardless of the politics and regardless of the politics of the people who show up in their courtrooms. I would never in my courtroom rule against somebody because they're a Democrat or because they're a Republican. Frankly, that would be insulting to even suggest, but that's the system we have, so we have to work with it.
Because it's said that justice is blind. What does that mean? The blind lady, what's that all about?
It's a symbol that we have used for hundreds of years as Americans to show that it doesn't matter when you show up into court what your politics are, who you are as a person, what your background is. You get fair justice, and the way you know you get fair justice is all of us together pass rules ahead of time that judges swear an oath to follow when they apply in a particular case.
So Lady Justice is the physical symbol. Lady Justice is wearing a blindfold, is that right?
That's the traditional way of expressing it, yes.
So she doesn't see, and Justice doesn't see, any of the particulars. You will usually have two parties. They could be corporations, they could be individuals, but what's the slogan that works? What are you running on if it's a slogan of the kind of law you try to practice?
Look, we need to have courts that are faster, that are smarter, that are fairer, and unfortunately, that is not always the case in Illinois. Look, Illinois has some of the most broken government in America, and it's an embarrassment to us as Illinoisans. And what we have an opportunity to do is we have the opportunity to make our courts fairer. And what that means is we need courts that are simply going to follow the law and let the chips fall. There's a reason judges wear black robes. They don't wear red robes. They don't wear blue robes. They wear black robes. And that symbolism that the courts have with Lady Justice, with the robes that judges wear, is important because it signifies you are supposed to get justice regardless of who you are and regardless of what your background is under the law.
So you're running for this. The people who can vote for you, they have to be registered to vote in one of 7 counties, right?
That's correct.
What are those 7 counties again?
All of DuPage County, all of Will County, Grundy, Iroquois, LaSalle, Bureau, Kankakee counties.
But you're not running to represent any particular, not DuPage.
No.
You happen to have lived in DuPage all your life, but you're trying to give the cases that are going to come to you are going to presumably in large part, if not exclusively, from matters that arose in the trial courts of those 7 counties, and they will come to the 3rd District because they have a right of appeal.
That's correct.
An automatic right of appeal. to take anything that happens in those trial courts, they can appeal that to the judgeships or the 7 judges.
Right. So
that you're running to be one of those 7 judges.
Let me sort of take a step back and just give people a quick background as to how our court structure works. You've got trial courts where I currently sit as a judge. I've been a judge on the trial court for 5 years. Anything that happens in that trial court, whether it's a criminal matter, whether it's a divorce matter, whether it's a lawsuit between 2 companies, whether it's a traffic ticket, anything that happens there, you can ask the judges upstairs on the appellate court to look over the shoulder of the trial judge. It's like replay review for sports. And then above the appellate court is the state Supreme Court, and then above that is the United States Supreme Court. Right. And I've worked in any and all levels of that, including earlier in my career, I worked at the United States Supreme Court.
Yeah, we didn't get there, but after you worked for Judge Wilkinson, a year or so after, you then applied for a clerkship with the United States Supreme Court.
Correct.
Even apply, it's enormously competitive and selective. Each justice, there are 9, of course, justices on the U.S. Supreme Court. Each has 4 clerks, right?
That's correct.
And do you apply to all of the justices on the Supreme Court and hoping you get one?
You do. You're applying for one of 36 spots. You better apply to all 9 of them. And so I did.
And you got one. Who was that justice?
I did. I clerked for Clarence Thomas.
So how well do you know the process on the Supreme Court in terms of working with them, how these opinions are considered or deliberated on and then written? How well do you know that process?
Considering that was my job, I know it very well. Okay. What people don't understand is there's no permanent legal staff at either the Federal Court of Appeals where I worked or at the U.S. Supreme Court where I worked. There's the judge or justice, and then they'll typically have 3 or 4 law clerks, and those 4 or 5 individuals do all of the substantive legal work. So there are if an opinion needs to be written, the law clerk writes it in conjunction with the judge, making sure they're doing what the judge wants, and then that's how the process works. So to your question, I'm very familiar with how that appellate process works.
Yeah, so you are extraordinarily familiar. Perhaps we'll have your opponent on. I'm not pushing people one way or the other, but we're examining your qualifications. And it would seem if somebody examined the qualifications to be an appellate judge here in the state of Illinois, well, what's this guy done? Has he done appellate work? Yes, on the federal appellate level, on the U.S. Supreme Court. And people might say, well, what do you know about how it would work in the state of Illinois on the 3rd District? How similar is that process?
The process in how an appellate court works is similar throughout the country, both federal and appellate, federal and state. And the other thing is my entire practice after I left the Supreme Court up until the time when I went on the bench was a uniquely appellate practice. When you work at the Supreme Court, it's a little bit like getting picked for the all-star team in your rookie year. And then after that, you have the opportunity. So I went and worked for one of the largest law firms in the world, and my job was I was in the appellate group. So what I did is I practiced throughout the country doing appeals in different courts in different locations.
And that was at Jones Day.
That's at Jones Day.
One of the largest worldwide law firms based here in the United States, but in terms of offices around the world.
The firm had, at the time I was there, 42 offices on 5 continents.
And so back to detention. Tell
Sure.
us a little bit about the law. You're a trial judge in DuPage, and under the new law, the Safety Act, when a person is arrested, what happens? How does that relate to detention?
Well, that person is required to be brought in front of a trial judge like myself within a very short period of time. It's depending on what the charge is, 24 to 48 hours. And then the judge has to make a determination as to whether that individual is let out onto the street or whether that individual stays in jail while they're awaiting their trial.
He has to make a determination as to whether this individual should be released.
Correct.
And what are the criteria that the Safety Act sends out? I think they do. As to the law, what are the criteria that the trial court judge in the first instance would look at to make that determination?
Well, there are a number of criteria, but the starting point is whether the particular crime that has been charged even is one that is eligible for someone to be detained, because the state legislature made some decisions about what types of crimes could or could not be detained.
So these are presumably the more serious crimes, the more serious likelihood that the person arrested might be dangerous to the community if he were released or she were released.
That's probably a fair shorthand.
Dangerous, yeah.
Yes, because within the list of crimes, and you can kind of think of them in terms of, there's obviously a long list, but think of them in terms of, did somebody get killed or did somebody get hurt very badly? Those are the types of crimes that people can be detained for, or was there a threat of violence involved? In those instances, what people don't understand is that even in those instances, the state prosecutor, the state's attorney, must ask the judge to detain the person before the judge has any discretion to make that decision at all. So that's your next step on the road.
The state's attorney is key, because if he or she doesn't ask, the judge can't on his own make the decision to detain, right?
That's correct. The judge can be sitting there and the judge could see anything up to and including first-degree murder. And if the state's attorney has not asked to have that individual detained, the judge has no choice.
So when the prosecutor, if they ask, then there has to be a hearing. They make their case, presumably the defense counsel or the
You have a right to appointed counsel.
Yeah, so there will be a clash of ideas, and the prosecutor will make his or her case. That's the state's attorney or assistant state's attorney for that county.
That's correct.
And then the public defender or the private defense counsel will make the case for that defendant being released, having his or her freedom. Do I get that right?
That's in layman's terms. That's exactly right.
Okay.
Yeah.
So that's what you're doing now.
And the determination that's made is is this individual a threat to another individual or to the community, or is this individual a willful flight risk? And you can get much more nuanced than that, but those are the two general buckets that the trial court is looking at. And then, obviously, once that determination is made, you go from there. You need to have judges who are very focused in applying the law properly so that individuals who should be detained will be detained. And you need to remember there is obviously a presumption of innocence that everyone, when they're accused of a crime, is entitled to. But at the same time, you need to be able to have judges who are going to go through that process and make that determination. Is this person too dangerous to someone or to the community to be released? Is this person likely to be a willful flight risk? And then the important part that people don't understand is when that determination is made, that criminal defendant has a right to ask the appellate court, nevertheless, to let that person out of jail.
Yeah, because the appellate court is backstopping that decision, right?
Correct.
Because they're looking at it and saying, because he or she, as the defendant, has the right to ask, and it goes to the appellate court, and then you folks, one of you, or there are 7 in the 3rd district, a panel of three
makes that decision, yes.
Will make a decision. Did they get it right? And it could, if they decided, yes, the trial judge decided should be detained, well, if they got it wrong, you would decide, no, there really wasn't a danger here. In some of the cases, the prosecutor may have asked for detention, and he or she didn't get it, and the prosecutor could appeal.
That's correct.
Say, this person's too dangerous to let out. The judge decided he should. We're asking you to reverse that. Right?
You've laid out generally what that process looks like. Right. Yes, the bottom line is appellate courts exist to fix mistakes that are made at the trial court. That's the whole reason we have them. And when the appellate court is looking at that question in the context of detention under the Safety Act, they are making a determination of one of two things. Either a criminal defendant was found to be too dangerous to release or was a flight risk. Was that decision correct? Question 2, in the event that the trial court decided someone was not too dangerous to release and the state's attorney disagreed and asked for a review of that, the appellate court can say, no, this person was too dangerous. This person needs to stay in jail pending trial. Those are the two decisions the appellate court has to make in the pretrial detention context.
And to make that decision when whether you're a trial judge or whether you're an appellate judge, to go either way, you don't do it just willy-nilly.
No.
There is the Safety Act, which sets out criteria, and then there may be other cases, precedent, that apply. Is that the gamut, or is there anything else you would look at as a trial judge or as an appellate judge?
Those are going to be the main things that you're looking at. Statutory text, the record that the trial court created when it made its detention determination, and then any similar cases, including state Supreme Court review cases or other appellate court cases that might have similar facts to what you're dealing with. Those are the general framework. And the question that you need to be asking and that voters need to be asking is a judge going to apply the law wherever that law takes them? Or is that judge, as many judges do, saying expressly, I want to be a politician, vote for me because of my party affiliation? If a judge is saying that, they don't understand what a judge does, because they're telling you that partisanship is more important. I can promise you, the voters of Illinois, the voters of the 3rd District, the only thing that matters to me is passing fair judgment based on the laws that all of you put into effect through your legislators. That's my commitment. That's what I will do. So the product on a trial court is pretty straightforward. Your job as a trial court is to help people resolve disputes that they can't resolve themselves. The overwhelming majority of cases settle because people want to control their destiny. They want to be able to have control over how their cases get resolved. If that doesn't work, then you deal with a trial, and ultimately a decision is rendered as to who's guilty or innocent, whether somebody's liable or not, whether somebody has to pay a fine, whether somebody does jail time, whatever that may be. That's the trial court. The second piece of your question is, what does an appellate court do? An appellate court, people don't understand typically, it's a writing job. People think of lawyers and juries and witnesses and My Cousin Vinny and all of those things. That's trial court. Once you get to the appellate court, all of the decisions as to what happened have been made. And the appellate court is looking over the shoulder of the trial court and is ultimately writing an opinion that says, yes, everything was done correctly, or no, there were mistakes made and here's how we need to fix them. That's the product an appellate court puts out.
The generic thing is, you want a judge, trial judge or appellate judge, to be applying the law to the facts. And the law could be in statutes, it could be in the Constitution, that's the law. Isn't that what you want? As opposed to saying, put them all in jail, lock them up, or let them all out. That's not applying the law to the facts.
No, it's not.
But there are some people who might do that. We don't want that, do we?
I have no idea what other people might do, but that would be what you just described would be the opposite of justice.
Because you want to be doing what generically?
We are a nation of laws to apply fair decisions that get decided the same way for everyone. Basic fairness. That's what we're looking for from our courts.
So that's the core question people are asking. Is this guy who's currently a judge in DuPage County and wants to be an appellate judge on the 3rd District, can they trust you? Does he have the qualifications? Does he understand justice and how we deliver justice? And is he fair? Is that pretty much the questions that you should be asking?
That's certainly a very important question. And the way I would be looking at that, if I'm a voter, frankly, ask the lawyers who show up in my courtroom. And the good news is we don't have to go out and ask them individually, because they did a bar poll where the lawyers went and asked all the lawyers were asked, how does Judge Skarin do his job? And the lawyers who responded gave me the highest marks of anybody running for this office in categories like impartiality, legal knowledge, meets the requirements of office, integrity. Those are the people who show up in front of me every single day. And I'm actually very proud and very honored that they thought that and were willing to say that about me.
So we're taping this on March 25. We just finished the primary. You didn't have any opposition in your primary, but now you're officially the nominee of the Republican Party for this particular seat.
That's correct.
There are 7 seats in the 3rd District. you're running for this one seat and there's a Democrat running against you, right?
That's correct.
And that'll be decided on November 5.
One of the things I hear a lot from people is, I just don't know who to vote for judge. And that's a fault of the candidates. That's a fault of the candidates not going out and explaining to the people who they are and what they believe and how they think the job should be done.
But if they will go to your website,
JudgeKenton.com.
JudgeKenton.com.
Yeah.
JudgeKenton.com. So you're going with your first name, is that right?
Correct.
Okay, because that's okay. They can call you Judge Kenton. They can call you Kenton. Probably wouldn't mind. But most people say Your Honor or Judge, right?
Most people do. My rule is, if you run into me on the street, don't call me Judge. Yeah. It's in a courtroom, that's fine.
Kenton does it.
Kenton does it.
And the thing is, when they go to your website, they might not find this in other websites. You go through a lot of what it takes to be an appellate judge.
I do.
You go through how you get to the Supreme Court as a law clerk.
I do.
You go through all of this stuff. A lot of this stuff, it's kind of redundant, okay? If you watch the show, you know it, but you may want to reinforce it. And you're going to be out there.
Well, let me put it this way. My commitment to the voters when I started running was they need to be able to understand what an appellate court is, what an appellate court does, why it matters, what makes a good judge. So those are all things that I've laid out and tried to explain on my website, JudgeKenton.com, so that people can understand who to vote for. Because all of you, the voters watching, you want to understand who to vote for. And too often, that information's just not available. So I've done my best to present to you what it is that matters and how I think that you should be making your decisions.
And so we'll just wrap with, we've talked about detention, we've talked about crime, we've talked about how important that detention decision is, because it number one, you detain, if you do it right, the dangerous people. And so they can be locked up for a long time because there can be days, months, years between arrest and trial, right?
Sure. You have a speedy trial right, but often that will get told for various reasons.
For various reasons, right. So
you could spend a very long time in jail waiting trial.
And so you want to make sure you get that right. On the other hand, you don't want somebody out when they should, if they are dangerous or they are a flight risk. So when you're voting for, this is one of numerous issues that you're deciding now as a judge, you would be deciding as an appellate judge if elected, and they want to make sure, these voters, that you get these things right, because here, if they get it wrong on the trial level, you're the backstop. And if you get it wrong, then the Illinois Supreme Court backstops, and then occasionally it goes to the U.S. Supreme Court. So there are lots of backstopping, but it helps if you get it right down either at the trial level or at the initial appellate.
It helps to get it right at the first time. And the other thing people need to understand is you have an absolute right to appeal from the trial court to the appellate court that I'm running for. Subject to some limited exceptions, you don't have a right to go to the state Supreme Court or to the U.S. Supreme Court. People like to say, I'm taking it to the Supreme Court. Well, you have a right to take it to the appellate court.
Right.
Beyond that, in most instances, it's up to the Supreme Court as to whether they want to take your case. Okay. So it's very important to have judges who are going to do it right, do it fair, and do it with excellence on our courts.
Right. So thank you so much, Judge Kenton Skarin, for coming here and elaborating and informing and educating. And thank you for watching the show. Come on back to Public Affairs. We hope to be doing perhaps 4 or 5 with Judge Kenton Skarin as he runs in this election that will be ultimately have an election day of November 5, but as you said 40 days before. So the point is, he said it's important to get it right. It's important that you get it right as a voter. It's important that you get informed and you know enough to vote to make the best possible decision. Come back next week and every week to Public Affairs.